where you had tape recordings which specifically identified conversations which you could consider criminal in nature. But absent that type of evidence, these cases are very difficult to bring, very complex, and frankly are often daunting for the prosecutor, and so they don't come.
Lynn Turner, does that sound right to you? Diffused responsibility and hard to prove intent.
I probably differ with Tony on that one. I think there's a number of issues here. You got to keep in mind that during the S&L crisis, we had 1,000 people charged or convicted, and we've only got about 3940 to date. We also had very complex cases in Enron, WorldCom, many of the corporate scandals. Those were just as complex as these are this time, and yet there was prosecution then. A decade later, no prosecution. I think it runs to the heart of some of the problems in Washington. I just think there's a lack of resources for prosecutors, and I think there's a lack of willingness on the part of prosecutors to bring cases.
A lack of resources? Does that mean your old agency, the SEC, isn't capable of bringing these kinds of cases any longer?
When you look at the case they brought against Goldman Sachs, the investment banking firm, on the large transaction called Abacus, they had a grand total of about 4 attorneys to work on that case. On the flip side, on the Goldman case, they would have had dozens backing up the defense. So it's almost like a David versus Goliath type battle. The other thing, though, that also enters into it is there's a tremendous revolving door between the attorneys at the SEC and the law firms who defend these people. And people at the SEC know that ultimately they'd like to get a job in one of those firms. So there, at times, it's been demonstrated that they're reluctant really to take on and go very aggressively against those firms.
Eve Smith, when you look back at the last several years, companies run into the ground, the economy almost run off the rails. What should have happened that didn't happen?
Well, I would agree with Lynn on this one. I think this is a matter of will rather than ability to perfect cases. There were, and it's interesting that he mentioned, specifically the Enron prosecution. There was a series of laws put into place after Enron called Sarbanes-Oxley, and those really have not been used in any serious way in prosecuting executives. One of the provisions of the Sarbanes-Oxley rules is that senior executives, and it's typically at least the chief executive officer and the CFO, have to certify that internal controls are adequate. For a big financial firm, that has to include their risk controls. A willful violation is, a knowing violation is punishable by up to 5 years in jail time. Willful violation is 20 years of jail time. But no one's gone after these sort of theories seriously. And the big reason, it's even worse than Lynn alludes, is, although what he says about the revolving door is 100% true, is the role that big banks play in campaign finance. They're the second biggest donors in Washington, second only to the healthcare industry. And for any case to be pursued as a criminal case, it isn't just the Securities and Exchange Commission. They can't pursue criminal cases on their own. They have to be pursued in conjunction with the Department of Justice. And the Department of Justice has been notably absent on this beat.
Mark Calabria, when you look at the system and the way it's behaving so far, have people who have committed crimes actually been in some jeopardy after the fact?
Well, not that we can tell for those who have committed crimes, and I don't think it's an either or. I do think there's a very high level to prove intent in criminal cases, and as someone who cares about the rights of the accused, I think that that's something that there should be a high level. But I would agree as well that there's a difference in will, and part of this is, of course, is many of these firms are still getting tremendous taxpayer assistance. So you have this conflict of interest, essentially, from the regulator, from the bank regulators saying, I don't want this institution to fail on my watch, so, of course, I don't want the SEC to go after it, for instance. Or if you look at, for instance, a taxpayer, for instance, has paid the defense fees for former executives from Fannie Mae and Freddie Mac. So, of course, if the SEC is going to look at this and say, well, I might get a judgment, but if the taxpayer is going to pay it, where's the justice in that? And now, of course, there's a revolving door issue here that I think is very real, but there's also an issue where, from the perspective of the firm and the perspective of the SEC, the Securities and Exchange Commission, sometimes getting a settlement they look at that as a win-win for themselves. They can have a big press conference. The number sounds very impressive, even if it's actually quite small compared to the size of the firm. But the lawyers of the SEC can say, we got a settlement, we won. The company in question can say, well, we didn't admit to do any wrongdoing and we made this go away. So one, I think if more of these resources, if you ended up having to take less cases, but take those cases actually further to get them to court, because in the case of settlements, it's really he said, she said. We never really know the facts of the case. We never know whether there's any real wrongdoing. And of course, for instance, one judge in New York has said, I'm not going to sign off on this. I need to see some facts here. And I think we need to see more of that, where these facts get out before the public so we actually know whether there was criminal behavior or not. And in these numerous settlements, we simply don't ever get to see the facts.
Mr. Valoukas, there is a poster making the rounds on the internet that says, imagine if they went after corporate criminals the way they go after people who set up tents in a park. Is there a public role here that prosecutors understand, that they keep one eye on the law books, but they also understand that they operate in an arena where there's public will and then there's the black and white letter of the law?
Well, I think that you can't confuse the issue of investigations with prosecutions and successful prosecutions. Most people in the Department of Justice, U.S. Attorney's Office, that I've had experience with, would be stunned to hear that someone thinks that they're being less than aggressive because they may go out and work for a firm afterwards. By and large, the most successful prosecutions are brought from the sophisticated office, involve enormous resources, and a commitment by people that they're going to do their best to represent their client, the U.S. people. The difficulty is that if the proof isn't there, in proof beyond a reasonable doubt, and that's the standard you're talking about, no matter what you want to do, unless you're going to play to the crowd, you're not going to responsibly bring a prosecution that you don't think should be brought. And that's the difficulty here. If the evidence isn't there, you can't bring the case. Now, these cases are brought, and you'll hear people saying, as you did, for instance, in the situation involving the insider trading cases, that they wanted to send a message. Same reason that the Department of Justice will bring prosecutions in tax cases in April, so as to send a message. So there's a desire to send the message in these cases, but the question is, can they prove it beyond a reasonable doubt? And if they can't, then no matter what it is that people are clamoring and no matter what people are saying on television, they should not responsibly bring those cases.
Well, I've been at enough news conferences where you've announced white-collar prosecutions, and sending a message was certainly part of the formula. Does the public faith in the operation of a marketplace depend on some confidence that it is being regulated, is being watched, is being policed?
Critical to what's going on, both from the standpoint of believing that miscreants will be punished for their conduct, but I think equally important, and I think this is where we get off what's really significant here. What's significant in the first instance is to try to prevent these activities from taking place. That is to say, undue risk being incurred, people willing to gamble with the public's money, and being able to say afterwards, well, I relied on my accountants or somebody else to tell me whether or not what I was doing was within the chalk lines, and frequently finding that, in fact, they were given that advice. If the regulations aren't in place, which aren't specific to the issues which are being faced by these institutions, then no, all of the prosecutions in the world afterwards are not going to prevent the disasters that we've seen, including Lehman and the most frequent, the matters that are coming up most recently. So that's where the focus needs to be in the first instance, on the regulation and the regulators. And there I think there's been failure.
Yves Smith, one of the most frequently cited points of anger from the Occupy demonstrators in cities around the country is that lack of prosecution. Is that a fair comment? Is the public right to be angry?
No, I think that's correct. I mean, in fact, and as I indicated before, there's been a failure to pursue theories and ways of getting information that appear to be very viable. You know, Lynn discussed how under-resourced the SEC is, yet you have Catherine Cortez Masto in Nevada, a state attorney general. You know, they don't even remotely have the resources that any federal agency has. She has started by launching a criminal case. Now, admittedly, it's against 2 lower-level employees at a vendor to bank servicers. But this is a classic, the same strategy they use in mafia prosecutions. You know, if these 2 individuals who have been charged are actually found guilty, they face 30 years each in jail time. They're going to roll. And they in turn, and the firm where they worked provides all of the software for the bank servicers. There have been allegations from foreclosure attorneys that these firms engage in systematic abuse of homeowners in the way that they charge fees, that they charge impermissible fees, double charge investors as well as the homeowner, and charge the fees in an illegal manner. And it's hard-coded in the software. I mean, there are theories out there that no one has gone after. And if you see state attorneys general are able to prove them, that calls into the question the notion that these aren't viable, that people can't be brought to justice.
Lynn Turner, is there still time to go after people who are demonstrated to have been bad actors in the meltdown?
Well, certainly we're going to be running up against statute of fraud limitations here, which say that within a reasonable period of time, you've got to bring the cases. So the clock is ticking here, and the longer we get past when someone might have actually committed a violation of the law, the chances of seeing something happen are going to disappear. And it appears that the government has already decided on some of these companies, such as an AIG that required a $150, $200 billion bailout, that they're not going to do anything. And so I think time is quickly passing us by here, which I think is also frustrating to the public.
Would people behave differently, Mark Calabria, if they had a reasonable expectation that they might be prosecuted for operating on the edge of the law, let's say?
While I think it's certainly important to go after wrongdoers, I do think there's a real risk we run that we paint this as bad people, a few bad people did a few bad things, and if we clear that up, everything's all right. Because I think the problems in our financial system are systemic. I think they run far deeper than just a few bad people. I think the bad incentives you have, and it was mentioned earlier, regulation is one set of incentives. Another set of incentives is market discipline, whether the firm itself would be able to go out of business, the monetary loss that an individual and executive might suffer if they are engaged in fraud or if they're just engaged in bad management. So I think we need to focus on, and I'll be very clear, I don't believe that the Dodd-Frank Act fixed too big to fail and fixed other problems in our system. So I think we need to go back and look at the systemic problems, because I think even if not one criminal action happened, we'd still be largely where we are today. So again, we need to be able to fix those systemic things. And that's not to say we shouldn't go after prosecutors. I will say, as an aside, I disagree slightly with that state attorney generals don't have resources. As we've seen in the past with tobacco cases, they have no reluctance to outsource their job to trial bar firms that are more than happy to do that work for them if there's actually a potential payoff at the end of the day for them. So there's tremendous amount of resources there. But again, I think the focusing on criminal behavior, while it's appropriate, should not make us lose sight of what was essentially irresponsible behavior driven by perverse incentives.
Mark Calabria, Eve Smith, Lynn Turner, Anton Valukas, thank you all.